Just before we start, just picking up on an issue you raised yesterday, Mr. Emmett. I understand there's been some discussions overnight or this morning about some further potential either non-publication orders or redactions to documents in the tender bundle.
In relation to further orders, can I take instructions on that?
Of course you can. The point of me raising it was just to raise with you whether there's something more I need to do, even in the interim, as to whilst those matters are being worked out and redactions are being done, if there's something that you or those instructing you would like me to do by way of protective orders, if I can put it that way, you'll just let me know and perhaps liaise with counsel assisting.
This may not be the only thing we would seek to the extent necessary is before anything enters might otherwise enter the public domain is interim orders to protect any order over which a claim has been made.
Yes.
I understand that in relation to the initial tranche, that is the tender bundle that was served last week or circulated last week, I understand all applications that have been made by the council you Commissioner have made orders in respect of those.
Okay.
So I understand those behind it. That's wrong. I understand that's been dealt with in relation to the further documents that came over the weekend and this morning. I imagine of course the council may still be considering its position.
In any event, if there's something that you would ask me to do either in the interim or on a more final basis, you just liaise with counsel assisting and let me know.
I'm grateful, Commissioner, we will.
Thank you.
Commissioner, if there's no other administrative matters.
Is there any more for me to do before we start the evidence?
I call Adam Danzy.
Thank you, Mr. Danzy. Just come forward. And Mr. Danzy, would you like to take an oath or an affirmation? An oath. It's a bit awkward to stay standing.
Do you solemnly and sincerely declare and affirm that the evidence that you shall give will be the truth, the whole truth, and nothing but the truth? Please, if so, please say I do.
I do.
Thank you, Mr. Danzy. Yes, Ms. McCall.
Please state your full name.
Adam Kenneth Brandon Danzy.
Mr. Danzy, what is your current occupation?
I'm Director of Workforce and Legal at Local Government New South Wales.
Would you explain what Local Government New South Wales is?
Local Government New South Wales is the peak industry association for local government in New South Wales. We a registered industrial organisation of employers under the Industrial Relations Act in New South Wales and also the Fair Work Act. We provide a range of specialist services to members, including industrial relations, unemployment work, policy, advice and assistance. We advocate the views and interests of our members to government.
Is Liverpool City Council a member of the Local Government New South Wales?
Yes, it is.
Have you, or to your knowledge, other officers of Local Government New South Wales in the past provided advice or assistance to Liverpool City Council?
Yes, I have, and other members of the team have, yes.
The questions I'm going to ask today focus at a high level of evidence about employment and industrial relations within the local government sector. I do not intend to ask you questions about anything in particular in respect of Liverpool City Council. Now, I want to start by asking you some questions about the employment conditions for council employees. In asking these questions, I want to break it up into two time periods. The first time period that I want to ask you about is up until the 31st of August last year. Now, as at the 1st of September, I think was when the changes were implemented. Up until the 1st of September, Was there a particular position or term of designated senior staff?
Yes, there was.
What was that?
Yes, so up until that point in time, the councillors could determine a position to be a senior staff position, and once so determined to be a senior staff position, then different arrangements applied to those positions by virtue of section 340 of the Local Government Act.
I'm going to come back to senior staff positions, but for the moment, in asking you questions about conditions of employment for council staff up until the 1st of September of last year, can we put to one side designated senior staff? Now, for other employees of council, how were their conditions of employment determined?
Yes, so for other employees, they would be covered by awards or enterprise agreements. In the case of Liverpool City Council, I don't believe they have an enterprise agreement, so they would have been covered by the primarily the Local Government State Award. So that would have covered the vast majority of employees. There are a number of other local government awards that can apply to some employees as well, but by and large, the Local Government State Award.
Those other awards, are they usually specialist awards? For example, an aged care, local government aged care award or something?
Correct, yes. So we've got the Local Government Age, Disability and Home Care State Award. We've got a Local Government Electricians Award. So they tend to be more occupation focused as opposed to industry focused.
Just excuse me for a minute. Commissioner, I don't know, does the microphone, may I inquire, amplify or?
If it can amplify a little more, that would assist me. Yes.
Yes.
There is a tipping point at which I understand it starts to interfere with all the microphones, but if it could be pushed up a little higher, that would be helpful.
Could you?
Of course.
Now, you spoke about an award, that's the Local Government State Award.
Yes, yep.
Associate, could you bring up the following document within the hearing room? INQ.012.001.0007. And I'm hoping that will appear on your screen, Mr. Dan, or big screen on the screen in front of you.
Sorry, please repeat. Number.
INQ.012.001.0007.
I am about to show document INQ.012.001.0007. Do you want this document shown on the live stream?
Yes, thank you. Now, I'll take you to certain pages, but that's the first page indicating that it's the Local Government State Award 2023. I understand there might have been some amendments to the award subsequently, but we're just relying on this particular version.
Understood.
Now, in determining conditions of employment of employees of a local council covered by the award, is one of the starting points clause 6, the school descriptors?
Yes.
And associate, that's at _0015. And on the body of the document, it's actually page 7 down the bottom. And we might, yes, that would be great if you could expand that maybe a little bit more. Now, Mr. Danzy, this clause, states the award structure consists of skill-based bands and levels that are defined according to the following skill descriptors. And just taking you through that, we start with an operational band level 1.
Yes.
There are different levels for that band. And if we could go to the next page, which is underscore 0016, you can see at about point 5 of the page, we then move to a different band entitled Administrative Technical Trades Band, Band 2.
Yes.
Then if you go to the next page, underscore 0017, down the bottom, we've got Professional Stroke Specialist Band 3, Level 1.
Yes.
And then if you go across to underscore 0019, right down the bottom of the page, we see Band 4, which is entitled Executive Band 4.
Yes.
Now, just very briefly, would you describe to the Commissioner the different bands and how they operate?
Yeah, sure. So the award is what we call a skills-based award, and under the award, employees are paid based upon acquisition and use of skill. So when a new employee comes into local government, one of the first things to do is identify which of the bands they fall in. So the operation band tends to be your outdoor type work, so parks and gardens staff, for example. The next band is your administrative and technical trades band, Band 2. That band, as the name suggests, deals with administrative staff, but also your technical and trade employees. Band 3 is our professional specialist band, typically your degree qualified type positions, and then also your executive band, which is moving into the director space.
Now, when determining the rates of pay, are they determined by a separate document which is referred to in the award a salary system?
Yes, they are.
Are salary systems unique to each council?
Yes, they are.
And if we then can go to 20, if we first look at clause 7 under rates of pay, it talks about the rates of pay are established for positions with the skill descriptors as defined in clause 6, which we just took you to, and they are entry levels of rates of pay only. And then under 7 Roman 2, there is a reference to the employer introducing a salary system to complement the skills-based structure and rates of pay of the award.
Yes, that's correct.
And then if you look at clause 8, that provides further details of what has to be included in a council salary system.
Correct, yes.
Now, you gave evidence that a salary system is unique for each council. How does the salary system establish the pay, for example, for a professional specialist planner who is classified as a Band 3 Level 1?
Yep. So firstly, you start off. So the award sets the industry minimum rates, but then the award also requires in clause 7 that each council have a salary system and as it indicates, the salary system complements the skills-based structure of the award. So each council will have a salary system structure with a number of grades. Each grade will correspond with a band and level of the award. And then under the salary system structure, the structure will provide a number of progression steps based on either acquisition and use of skill or employee performance. So this. Sorry.
No, keep on going.
No, well, that's basically, yeah.
So again, using a hypothetical example of the planner, we've got his particular band within the award. We would then look at the salary system and he or she would be allocated a particular grade.
Correct.
And then within that grade, there are progression steps which can be based on the acquisition of skill for at least one of them. That's
right. So under when we look under the clause 8 of the award, it talks about the salary system structure. So under a council salary system structure can provide for progression based on either acquisition, use of skill or employee performance. But when we move into the employee performance progression, there has to be at least one skills-based progression step, and that's reflected in clause 8 Roman 4B.
With a person who is appointed to a particular grade with the progression steps, assuming the grade is a standalone grade, by the time that they move up the various progression steps, is that the, in a sense, maximum grade and then hence maximum salary that they'll achieve under the salary system?
Under the salary system, yes, because employees do top out in their grade. Mm-hmm. So for the purposes of the salary system, yes, once you reach your top progression step, then you've achieved the maximum progression based on the salary system structure.
For those employees, are there other potential components of payment of either wages or salaries or allowance, amount of remuneration they receive from their employment?
Yes, there can be. So we tend to talk about the terminology we tend to refer to as total reward. And so there's a number of components of the total reward. So the industry, as the award sets the industry minimum, and then above the industry minimum, the award requires councils to have a salary system. So then the salary system becomes, if you like, the effective minimum award rate at the enterprise level. The award also then has a number of other award-related payments, so allowances, shift penalties and the like. And then beyond the award payments, councils can then provide above award benefits to attract and retain staff. So that might be things like a market rate, for example.
We have seen in some of the evidence before the inquiry this term market rate. So as you've just given evidence, that is potentially a component in the total remuneration being received by an employee. And the example you gave was where there might be a need to attract a planner with this particular skill. They're scarce in the labour market, and it's seen that to attract that person, an additional payment reflecting the market needs to be paid.
Yes, so our award is a minimum rates award, our award being the local government state award. It's a minimum rates award as distinct from a paid rates award. And so there is the capacity to pay over and above the award payments to attract and retain.
The market rate and determining what the market rate would be for a particular position, are there any resources that are available, either free or by paying for them, to a council to determine what the market rate is?
Yep, absolutely. There's our own organisation does a number of reports that councils can subscribe to. We have a local government remuneration report. There's a general manager remuneration report. Other organisations also run their own remuneration reports. So there's entities like Mercer, for example. So MacArthur's do remuneration reports. Our counterpart organisation in Western Australia, the Western Australian Local Government Association, they also do remuneration reports. So there's quite a number of different reports that can be accessed to get a sense of what the market what the market expects for particular positions.
So your organisation's local government remuneration report, does that, if you subscribe to it, does that provide comparative information, again using our planner as an example, that a planner within this band are receiving a total remuneration, is it?
It does. It picks up the total remuneration. Our report only goes down to a certain level, and just off the top of my head, I can't remember if planners are specifically identified in it. I think they are, but I'm not 100% certain.
Would it include employees in a directorship role? And what about a manager role?
Yes, managers are picked up.
And then the General Manager Remuneration Report, again, that's based on information provided to you by your constituent members about what they're paying their General Manager under his or her contract of employment.
Correct, yep.
Still dealing with the period up until the 1st of September of last year, the designated staff position, you've given evidence that that was a position where the council has designated a particular role to be a senior staff position.
Yes.
Once a position, withdraw that, within a council which has a structure of general manager, directors and managers, in your experience, which level of the executive were at times designated a senior staff position?
So it's generally the direct reports below general manager. So and there's been a few phases of changes to Section 332 of the Local Government Act. But I think in the period that you're talking about, yes, the senior staff were typically the direct reports to the general manager.
Now, once a position was designated as a senior staff position, what repercussion did that have as to what instrument or legal instrument determined salary and conditions of employment?
So once a position is designated a senior staff position, they cease to be covered by the arbitral functions of the Industrial Relations Commission, and therefore are not covered by awards or enterprise agreements, and are instead covered by a statutory contract approved by the Office of Local Government.
And compared to an employee covered by the award, access to the state tribunal system with for applications for unfair dismissal, if you were a designated senior staff position, was that available to you?
No, it was not.
So you were employed under a statutory contract, which would reflect the statutory contract devised by the Office of Local Government.
Correct.
And was that contract could be up until 5 years?
Yes, so minimum of 12 months, maximum of 5 years.
And again, terms of employment, and in particular rates of pay, that would be determined by the relevant contractual provisions dealing with remuneration.
For the senior staff?
Yeah.
Yes, so that's right. They have, so the actual, for the individual concerned, yes, it would be dealt with under their contract of employment and form part of their total remuneration package amount, which forms part of the contract.
Now, I'm putting to one side at the moment the general manager, and I referred you to that cut-off date of up until the 1st of September 2024. What occurred after the 1st of September 2024 in respect of designated senior staff positions?
Yes, so from 1 September 2024, the ability for councils to designate positions as senior staff positions was removed from the Act. Employees who were already on a senior staff contract went into a transitional phase, and under the transitional provisions of the amendment legislation, they could either remain on their statutory contract until its termination date, or they could request to transition across to award-based employment earlier than the termination date, and then councils could not unreasonably refuse that request.
Associate, we can take down that exhibit, thank you. So putting to one side, and we'll confine our to transition to the award system, any new director appointment will then be covered by the award?
Correct. So any new executive level employee employed after the 1st of September 2024 is required to be employed under either an award or an enterprise agreement, because there was no longer the availability of the statutory contract.
Now, I just asked for the exhibit to be taken down, but you'll remember there was that executive band.
Yep.
It was either 4 or 5. Is that the band that a director would then come within?
Yeah, so you could only have an employee on a senior staff contract prior to that 1st of September 2024 if the duties were commensurate with the executive band of the award. And so, yes, those people who are transitioning from senior staff employment to award-based employment, we're talking about the executive band level people under the award.
And the description that you gave about non-designated senior staff employment conditions, and in particular their salaries, they now apply to directors within the executive band who are either new appointments or who have transitioned. Correct.
So, yes, so they will now, moving forward, they will have a salary system rate of pay, so they'll be required to have a grade under the council salary system, and then other provisions of the award that are relevant will apply.
Including the potential for that additional market rate.
Correct, right? Yes, yep.
In your experience before the 1st of September 2024, looking at that level of management, the executive level of directorships, was it common for directors the respective directors of a council to be on the same salary, or did salaries differ? I'm sorry, do you
I think I understand. So can I maybe just make sure I've got the question right? Are you asking me whether directors at a particular council typically were all on the same remuneration.
Yeah.
I think it varies from council to council, but it will. I think the short answer is it varies from council to council.
The various components that you described for the other employees. So you look at the award, the salary system, any award allowances, and then you could have that additional benefit. If you go back to what is designated under a salary system for a particular director, again, can you comment on whether generally all directors receive the same level or within the salary system?
Well, not necessarily, because you still start on the base that the salary system, so the grade under the salary system is based on acquisition and use of skill. So you would be looking at the role, the position description, how big the position is, the level of authority, the level of accountability, the responsibilities, perhaps the market, the budget, not the market, the budget that they are responsible for. And so different director roles within a council will vary based on authority, skill, accountability, and that would impact on the salary system grade. And then, of course, so in terms of the award payments, that would be the first thing that could potentially differ. And then we've also got different markets as well. So councils could be paying directors different rates based on different markets, depending on the type of work that they do.
The question of the payment of a particular salary, for example, to a director, is that within the responsibility or jurisdiction of the general manager, or does the governing body of the council, either the mayor or councillors, have any decision-making role in respect of that?
So since 2016, the Section 332 of the Local Government Act has provided that the council is responsible for determining the allocation of resources for staffing in consultation with the General Manager. And then the General Manager is responsible for determining the positions within the organisation structure, having regard to the council's strategic plan and operational requirements. So when you look at that, so the answer is that the General Manager gets to make decisions on the remuneration to staff within any confines or parameters set by the council when they set the budget for staffing.
And as you said, those parameters are obviously the budget, which would include an identification of employees' salaries and benefits for next year of $1 million, let's say.
Yeah, so it's typically done as an aggregated amount. So the council will make a decision, a lump sum amount for staff-related, employment-related costs. Sometimes they can go a little bit further and break it into directorates, but they can't go to so far as positions, because that would then be, usurping the responsibility of the general managers. So councils can make a decision about allocation of resources for staffing. General manager then makes the decisions about the positions and then who goes into those positions.
The reason for the abolition of the designated senior staff position, do you know how that came about or why it came about?
Yes. You want me to answer it?
Yes.
Okay. Okay. So following Operation Dasher, which I can't remember exactly when, it was about 2020, 2021, I think, from memory, the Operation Dasher identified a potential corruption risk with the no-fault termination provision of the senior staff contract. There were a number of recommendations made. Local government unions were strongly of the view that the best solution for removing the corruption risk was to remove the statutory contract and to give employees protection from unfair dismissal. And our organisation ended up agreeing with the unions. Took us a while, but we eventually agreed with the unions on that. And so then there was a joint position from local government unions and local government New South Wales to see the abolition of the statutory contract for executive level employees.
The abolition of the senior staff position, the difference now for a director who either decided to transition to the awards system or a new appointment, is it primarily in that they're now given protection under the award, which includes the ability to bring unfair dismissal proceedings?
Yeah, that's exactly right. So that was the main change, if you like, is that by doing away with the statutory contract and bringing executive level employees under employment under the award, they now have protection from unfair dismissal.
With a director who was a designated senior staff member and subject to a contract, if their role was to be abolished while they were under the contract, their employment could be terminated?
Yes, there were termination provisions in the statutory contract, yes.
And, for example, if it was a termination because the role was being abolished, would they generally be entitled to a payment until the end of their contract?
So there was, under the senior staff contract, there was what we call the 10.3.5 provision, which was that a council could terminate the employment of a senior staff position by giving either 38 weeks notice or the balance of the contract, whichever was the lesser. And so using that example of a redundancy type scenario, that would be the payment that you would look to.
All right. So if you were a director and you only had a year of the term of your contract and the role was abolished, sorry, that's a bad example. If you only had 6 months for your contract, you would be entitled to a payout of the 6 months, not the 38 weeks.
Correct, yeah. Yes.
Now that a director is covered by the award, are they provided with additional protection or additional payments if it is a redundancy?
So the award does provide for notice and severance in the case of redundancy. Yes.
Now, can I turn to the General Manager?
Just before you do that, can I just raise something with Mr. Danzy? Before the changes came into effect on 1 September of last year, correct me if I'm wrong, but it was the obligation of the governing body to determine the senior staff positions within the council organisation structure. Is that right?
Yes, so from the period between 2016 to 2024, the wording of section 332 of the Local Government Act provided that councillors determine, one, the allocation. Oh, hang on, sorry, I think I've got the dates wrong. There was a councillors used to they did up. I'm trying to think when it changed. Sorry, just give me a moment.
That's right. Take your time.
And
if you need to come back to
it.
Councillors determined the direct reports. So prior to the removal of senior staff from the Local Government Act, councillors were responsible for determining effectively the senior staff positions, which were
The director level type
direct
positions.
reports to the general manager.
Yes, and now the difference is now, whilst the council, the governing body, I should say, determines the resources to be allocated to staffing generally, it's within the purview of the general manager to determine those direct reports or director positions.
In consultation with the
In
elected
consultation,
council, yes.
but the responsibility, there's a shift from that being a matter for the governing body to determine to it now being one for the general manager to determine, albeit after consulting the governing body.
Yeah, correct. So the state of play now is that the general manager is responsible for determining all of the positions in the organisation structure in consultation with the elected council.
Thank you.
Associate, could you please bring up exhibit INQ.012.001.0006?
I am about to show document INQ.012.001.0006. Do you want this document?
Yes. It's the Local Government Act, and you can see the currency of the version. It's up until to the 31st of August 2024.
Yes.
And could I take you to underscore page underscore 0233?
That's the provision I had in mind.
In answer to the Commissioner's questions, is this the relevant provision that was dealing with that question of determination of structure?
Yeah, that's right. So under 3321, you firstly see there that the council must, after consulting the general manager, determine A, the senior staff positions within the organisation structure of the council, and also B, the roles and reporting lines for other senior. It's not very well worded, but the intent being that the roles and reporting lines of the holders of senior staff positions, so that the governing body would determine senior staff positions and the roles and responsibilities of the senior staff positions.
And then also the resources to be allocated towards
Correct.
the employment of staff.
Correct, yes.
And then under 1A, the general manager must, after consulting the council, determine the positions other than senior staff positions within the organisation structure of the council.
Yes, correct.
And was that change also driven by the outcome of that inquiry? So
Yes.
that you mentioned earlier as part of this suite of changes to remove the designation of senior staff positions and also to make these changes to how the organisation structure and the positions that are to be determined?
Yes, so effectively now leave it to the general manager to determine the positions within the organisation structure in consultation with the elected council.
Thank you.
Could I take you to another exhibit, 2.001.0005?
I'm about to show document INQ.012.001.005. Do you want this document?
In Local Government Act, but a version, the current version, at least for the 23rd of May of this year, obviously incorporating those changes that came into effect on the 1st of September last year.
Yes.
And could we go to page underscore 0237? And down the bottom, section 332. Maybe we could expand that a little bit. Is this now the amended provision which deals with determination of structure,
Yes, it is.
which, as you said, seem to be part of the changes that were implemented after the ICAC inquiry.
Correct.
And as it states there, the council must, after consulting the general manager, determine the resources to be allocated towards employment of staff. Picking up on one of your previous answers, that's looking at an aggregate amount.
Yes, so the advice from the Office of Local Government, which we agree with, is that the council determines a lump sum, if you like, payment towards the employment costs.
And then under 1A, the general manager must, after consulting the council, determine the positions within the organisation structure of the council.
Yes, correct.
And again, the way it is worded, it is not looking at consultation with a particular member of the governing body like the mayor, but rather with the governing body, that is the council, the councillors, including the mayor.
Yes, correct. So it's effectively all of the councillors.
And then again, as 1B says, it's to be determined so as to give effect to the priorities set out in strategic plans and delivery program of the council.
Correct.
Now we're on to the general manager. Their position, to state the obvious, is not covered by the award.
Correct.
They are enter into a contract. Is the contract with the council or with the mayor?
It's with the council, but the mayor typically signs the contract on behalf of the council.
The terms and conditions contained in the contract, where do you find those? What are they based on?
So the Office of Local Government has a statutory contract. So under Section 338 of the Local Government Act, it provides that, in effect, where the Office of Local Government makes a statutory contract, councils are required to use it. And so there is a statutory contract for general managers. There has been since about 2006, and that sets the terms and conditions of employment.
And it's mandatory for a council to use that contract.
Correct.
The statutory contract itself could be amended by the Office of Local Government.
Correct.
And then within the contract, are there provisions which allow for certain clauses amendment by a council in respect of a contract with that particular mayor?
Yes. So
With that particular general manager, sorry.
yes. So there are limited circumstances where it can be amended by the council, or what I might call a variation, and they're referenced in, I think it's clause 19, variations of the contract. So it highlights where you can do a variation.
Now, the standard contract of employment for general managers, again, as a result of that ICAC investigation, did that lead to some, look, before asking you that, under the standard contract, there are provisions which allow, in certain circumstances, for the termination of the general manager's contract.
Correct.
That ability to terminate the contract, is that vested in the governing body of council?
Yes.
So it's not a decision that can be made solely by, for example, the mayor or a deputy mayor?
It's the council. The council.
And they have to pass a resolution at a council meeting?
Yes, there has to be some form of formal decision by the council.
The ability, and I'm just asking you this broadly, the ability for that governing body to terminate a contract of a general manager, in what circumstances are they given that ability?
So clause 10 of the contract sets out the various circumstances in which a contract can be terminated before the termination date. There were some changes to the contract in 2022. So if I get some of the clause references wrong, forgive me, but...
Can I just interrupt you for a minute? Just starting very broadly, there is a right to terminate, in a sense, with cause.
Correct.
And what's included under cause?
So there's a capacity under the contract to do a poor performance termination by paying 13 weeks notice or termination pay. So I think that's the one you're referring to.
Right. What about in circumstances where there is misconduct?
Yep. So there's a separate provision for summary dismissal, about 10.4.
And as it sounds, a summary dismissal is the contract is terminated with no further payments.
Correct.
And then is there, again, at a general level, a provision which allows termination of the contract without cause?
Correct. Yes.
So as it suggests, the council governing body can decide to terminate the contract with no reason, without anything like a poor performance or misconduct, and the repercussion of that is a particular level of payment?
Yes. So under the current version of the contract, 10.3.1e, which used to be the old 10.3.5 clause, a council can terminate the contract without providing a reason by giving of 38 weeks notice or the balance of the contract, whichever is the lesser.
Now, I interrupted you. There were some changes to the standard contract of employment for a general manager, which had an impact on this right of termination.
Yes. So in 2022, there was a new iteration of the statutory contract for general managers, where we, in relation to the what was then the 10.3.5, which is now 10.3.1e, if a council was to utilise that 38-week provision, then the general manager is entitled to request the reasons for the termination if they want the reasons. And then if they request them, they have to be provided with the reasons. That's what was one of the changes.
Was there also a change which allowed some form of mediation?
Yes. So the contract also changed to highlight the availability of mediation. So mediation was already referred to in the dispute resolution procedure, but I guess the industry parties took the view that we needed to highlight the availability of mediation. And so that was done in a number of respects. One, it makes it quite clear that the parties are entitled to request mediation. The contract also changed to provide that if a council refused a request for mediation, then the general manager is entitled to know the reasons for such refusal.
But under the new contractual provisions, you need both the council and the general manager to agree to mediation.
It's still an agreed process, yes.
Also, in respect of poor performance, if that is the nominated reason for terminating the contract, was there also a requirement that some kind of performance review had to be done?
Yes, so the 2022 change also made it clearer that if a council was going to utilise the termination for based on performance, that it had to be following a performance review, and that the general manager had to be afforded an opportunity to utilise the dispute resolution procedure in the contract. So again, I guess a reference back to the mediation and afforded an opportunity to address the concern.
Moving away from the area of termination, under the mandatory or the standard contract, is there a provision for regular performance review of a general manager?
Yes, so the contract provides that the performance has to be reviewed at least annually and can be reviewed more frequently by agreement. More frequently at the behest of the council. And sorry, on the mediation, one of the other changes was that the contract also now indicates that the parties can agree on a mediator at the time that they enter into the contract.
And with remuneration under the standard contract for a general manager, are there any provisions for like performance pay?
Yes. So under the statutory contract, so in terms of remuneration, are we talking about the post 2022 contract or the pre 2022 iteration? Both versions did provide for a pay increase based on performance.
Mm-hmm. What was the change that was introduced?
So the change that was introduced though in 2022 is that the performance pay is now for a 12-month, is for a 12-month period only, unless the council decides that it is to continue for the duration of the contract. So to get a performance-based adjustment, the employee has to have performance that is assessed as better than satisfactory following a performance review. And if the council is satisfied that the performance was better than satisfactory, they can grant a performance increase. But under the post-2022 version, that increase is for a 12-month period unless the council decides that it is to be for the duration of the contract.
Does that mean it's assessed for that 12-month period only rather than on a rolling basis? Is that
what
you mean?
So the issue that was identified prior to 2022 was that it wasn't really a performance payment if you got the increase in the first year of a 5-year contract and then you continue that payment, but not necessarily maintain the performance. So now you get a performance increase, or you can get a performance increase for better than satisfactory performance, but you only carry it for 12 months unless the council decides that it continues beyond that period.
I understand. Thank you.
I want to now turn to a different topic, and we can take down that exhibit. Thank you. And that topic is general employment by a council. In some of the material before the inquiry, at times there is a reference to a direct employment. Can I ask you, when the council want to employ somebody in a role and the person is currently outside the organisation, their entrance into that local government employment pool or employment family, can that be done first by a temporary contract?
So Section 351 of the Local Government Act does allow for temporary appointments. The limitation, though, is that you can only do a temporary appointment for up to 12 months or 24 months in the case of maternity relief.
An alternative way of becoming employed would be immediate employment under a contract in a permanent role.
Yeah, so you could engage somebody permanently by going through the advertising and merit selection process and then appointing them permanently to a position within the council structure.
Those requirements of advertising, etc., they're part of the Local Government Act?
Yes, so the advertising requirement is in 348 of the Local Government Act, and then the merit principle is in 349 of the Local Government Act.
And both of those provisions should be followed if somebody is with one exception, which I'll get to, if a person is being appointed to a permanent role within council.
Yeah, so to become a permanent feature of the local government family, if I could describe it that way, you have to go through an advertising and merit selection process.
Now, the exception that I referred to, is that where you're already employed by the council but as a permanent employee, but your employment or your role might shift in some way?
I think you might have been alluding to the 350 of the Local Government Act indicates or provides that the advertising and merit selection provisions or requirements don't apply when an appointment is by way of a lateral transfer or demotion, unless the council decides that they want those provisions to apply. So if it was taking an existing employee, as you say, and then wanting to move them into a comparable role but a different role, so lateral transfer, then you wouldn't have to go through the merit advertising and merit process to shift them across.
The terminology that I referred you to at the beginning of these questions of a direct employment, is that something you've come across in your work?
I think the terminology, if it's used, it would be in relation to lateral transfers. So if you're directly appointing someone because you're not going through an advertising and merit selection process, it's because you're already taking somebody who has been through that process, they're part of the local government family, and then you're directly appointing them into a lateral transfer position. And then there are also, for amalgamated councils, there's similar provisions which relax the rules where there's been a council amalgamation or boundary alteration as well.
The appointment of a person from outside the organisation to a temporary position, in a way it is a time period.
Yeah, so okay. So so you can appoint a person temporarily. So my terminology is that's a temporary appointment.
Yep.
It's a temporary appointment in accordance with 351 of the Local Government Act. Yes, you don't have to go through the usual advertising process to do a temporary appointment under Section 351 of the Local Government Act. So I guess the thinking is if you've got an emergency situation or sudden urgent need, you can bring somebody in very quickly to deal with that by putting them on as a temporary appointment.
Putting to one side the circumstances of replacing somebody who's on maternity leave, there is a time limitation of 12 months.
Correct.
And after the 12 months, that person's temporary contract cannot be renewed?
Correct. So once the 12 months is up, they either cease employment or council would go through an advertising and merit selection process to then bring them in permanently, potentially.
When you were asked some questions about the structure of the council and how the statutory provisions of who determines it either the general manager in consultation with the council, etc. Can I broaden that inquiry as to the relationship between the governing body and the general manager in terms of dealing with the actual operations of council? Are there any first statutory provisions which in a sense demarcate the involvement of the governing body in the actual operations of council?
So the functions of the general manager are set out in 335 of the Local Government Act. They include the day-to-day management of the council, the appointment and dismissal of staff. There's probably some other relevant things that relate to the operations, but it's the general manager's function to deal with the day-to-day administration of the council. And again, coming back to the structure, you would also look to that section 332 because it makes it quite clear the councillors are responsible for determining the allocation of resources for staffing, but the general manager is now responsible for determining the positions having regard to the council's strategic plan, etc.
Councillors are approached and deal with constituents, and constituents often raise particular issues or complaints about what's happening within their community. The role of a councillor in raising that, where it's really raising an operational matter, can I ask a series of questions? First, the ability of the councillor to agitate or raise that matter, is that governed by any statutory provisions other than 335 saying, General Manager, you deal with operational matters?
So, there's a whole layer of things here that we've got the Code of Conduct, that's the first thing. So the Local Government Act requires councils to have a Code of Conduct that's not inconsistent with Model Code of Conduct. So the Office of Local Government has issued a Model Code of Conduct for councils under their 23A provision of the Local Government Act. The Code of Conduct deals with appropriate and inappropriate interactions between councillors and staff. And so, for example, it's not appropriate for councillors to be discussing individual employee grievances with staff, but they can have a discussion about broader workforce issues. So that's dealt with in the Code of Conduct. There are also various other guidelines that the OLG have issued that also deal with that.
What about an example of a constituent who's contacted the council and said, my garbage hasn't been collected and this is a constant problem, and that councillor wants to contact somebody within the waste section of the council and have it and complain?
Yeah, so that would be inconsistent with the requirements of the Code of Conduct. Now, the councillor could raise it with the general manager, but they are not allowed to go to directly to staff about those individual matters.
You spoke about there are other OLG guidelines, procedures whereby a councillor can raise through the GM the fact the garbage is regularly not collected. In your experience, is that usually or often internal council procedure?
So the Office of Local Government, again, one of the guidelines that one of the requirements that they've put out is they require councils to have a policy on, I think it's called the Councillor and Staff Interaction Policy or something to that effect. Councils are required to have such a policy, And in that policy, it again deals with what are appropriate and inappropriate interactions between councillors and staff.
Could you just excuse me for a
Yes,
minute?
of course.
I have no further questions.
Mr. Danzy, just on interaction policies, and tell me if this is too general, but in your experience, is it often a feature of policies of that type that councillors will be permitted to contact the general manager and director level positions, depending on where their query lies?
Yeah, so under the OLG's model policy, it's been a while since I've looked at it.
That's all right.
From memory, Schedule 1 of the policy gives the council an opportunity to indicate who councillors can talk directly with. So, for example, they might indicate the directors in Schedule 1, and I think it then goes on with Schedule 2, which might then be other people that are able to talk to about specific issues. So,
someone beneath, I don't mean that I'll rephrase it, someone else within the organisation, not a director level, but who might have responsibility for a specific matter within the organisation that a councillor could go to in relation to that narrow area of responsibility.
So if they're not identified in the policy, they'd have to go through the general manager and seek the general manager's permission.
But if there was an interaction policy that said you could go to the general manager or a director if it's within that directorate, that wouldn't strike you as unusual?
If the council's decided that they think that that's okay, then that's okay.
But you've seen do I understand you're familiar, you've seen examples of that amongst the membership more broadly?
Yeah, so I think most councils follow the OLG template as it's written. And so you start off by saying, okay, Schedule 1,
yes,
these are directly about matters and they'll typically be your directors.
yes,
Schedule 2, I think, is more limited. It will be you can talk to these people, but only about specific areas within their area of expertise.
yes.
And then anything outside of that would be a no-no unless the general manager said it was okay.
And are policies like that important in your view, in
Absolutely.
the operation? Why?
Yeah. So that we don't have can be perceived as putting undue pressure, bullying, harassment on staff. So it's part of the work health and safety, I guess, of protecting the staff. Sorry.
That's all right. You're all right.
But I guess also we've got to remember the general manager is responsible for staffing, and so they are entitled to know what their staff are doing, who they're talking to, whether there are any issues or concerns. If the general manager's got them, then following those appropriate protocols and procedures, I think just protects that.
Anything arising out of that?
Yes, could I just ask, the OLG policy on councillor staff interaction, roughly when was that introduced?
Oh gosh, you're really testing me on this one. I can just say it was in the last 5 years, but I couldn't tell you when exactly.
And again, is it your understanding that if hypothetically a councillor was in breach of it, it may then ground a code of conduct complaint?
Yes.
Anyone seek leave to Mr. Dancy some questions?
Commissioner, I don't seek to examine Mr. Dancy. Can I just say this? No way any criticism of what's happened. Mr.
Yes.
Dancy has given you, Commissioner, a lot of evidence that is in the nature of questions of law or legal matters.
Sure.
I don't have any questions for Mr. Dancy, and there may end up being no dispute about any question law. If there is any question of law that you need that's appropriately debated by the party, we will be asking for our submission.
Of course, that's understood. Does anyone else ask Mr. Dancy's question?
No, thank you.
Thank you, Mr. Dancy, for your attendance and your assistance today. Mr. Dancy can be excused. Or would you prefer to reserve?
Commissioner, what I would seek is that at the moment, with the position with answering summons, that no witness be excused.
Yes, all right.
Obviously, when it's determined that there will be no need to hear from a particular witness, the assisting team will inform them as soon as possible. But if the moment for abundant caution, if witnesses could not be excused.
All right. Mr. Dancy has made a... Mr. Dancy, what that means is I won't formally excuse you from your summons. In the unlikely event that we need to get you back, we'll let you know. But as soon as a decision is made that you can be released, it'll be communicated to you. Thank you.
Our next witness isn't due until 12:30.
Okay. All right. Well, I'll adjourn, and if we can get started earlier, someone will let me know.
Yes.
Thank you. I'll adjourn until 12:30, or unless I'm told earlier.